Hi, and welcome back to Military Law Talks. So today's video is about SCOTUS, the Supreme Court of the United States, recent midnight ruling. And so over Easter weekend, SCOTUS released an order literally in the middle of the night, which in my, 20 years following the US Supreme Court is pretty unprecedented. I can't think of another time where on a holiday weekend, the Supreme Court in the middle of the night issues an order. But of course, it involves the immigration issues and all the cases that have been pending about the removal of illegal immigrants from, purported gang members and designated under President Trump a terrorist organization from Venezuela, and Venezuela is refusing to take them back. So they're being sent to a prison in El Salvador. Now, some individuals are actually from El Salvador. So like the one gang member that's been in the news and all over social media with the tattoos, and a senator even went to go visit him. He's actually from El Salvador. So he was sent back to his country where he is from. And so I've seen a whole bunch of stuff on social media. I've been asked personally a lot about this case. And so I decided, well, let me just read the opinions and go over do a video on it. So I'm actually going to do this video in two parts. And so if you're catching the live stream, you're going to get the full video, one long video. And then I'm going to release it in two different parts. And so if you're catching later the video release, you may want to watch the entire live stream or just watch both of the videos. Okay, so let's get into it. Okay, so this was this midnight order that came out in the middle of the night. So it was actually Good Friday night, but early Saturday morning. So it's dated as being released Saturday, April 19th. And so it is concerning this case. And I'm going to keep that in mind because I'm going to talk about two different cases that are interrelated. But this case is currently pending in Texas, and it's been appealed up to the Fifth Circuit. So this is a Texas case, and there's also related to this a DC case. So we're going to talk about both of those cases together. But in a sense, it's a lot of the same issues. And so this case, again, this kind of, in my opinion, unprecedented order. Now, maybe this has happened before, but I just not personally aware of it. But I think a pretty unprecedented order. So this is talking about, hey, this is this case that's pending in the Fifth Circuit, saying the government, you're invited to file a response. But specifically this highlighted portion, this is where the issue in this case arises. So this order was released in the middle of the night telling the government not to remove any member of the punitive class of detainees. So these would be the parties involved in this, really what's kind of been termed a class action, but it's not your typical class action, but it's a bunch of illegal aliens that are facing deportation joined in this lawsuit, all one big lawsuit, obviously against the government, against Donald Trump. And so they're saying the government can't remove any of these until there's further order from the court. But that's it. That's all it is. And then it says Justice Thomas and Alito have dissented from this court order, and there's going to be more to follow. So that's it. That's all that was released. All right, so let's take a look at really kind of, let's step back and take a look at how did we get to this point. Okay, so this is Justice Alito and Thomas's dissent to that order that I just reviewed, and it gives us more information of like, how did we get here? How did we get to this like midnight ruling telling the Trump administration to stop any deportations for that punitive class? So I interpreted that only applies to those members of that lawsuit. And so he explains it. So it says, shortly after midnight yesterday, the court hastily and prematurely granted unprecedented emergency relief. And I agree with that. Pretty unprecedented, right? And while the order doesn't say that it's a injunction, it sure has the practical effect of being an injunction, essentially stopping, enjoining a party from doing something. It orders the government, the executive branch. So we have, right, a tension between the judicial branch. Does the judicial branch really have the power to tell the executive branch not to engage in, well, I'm sure the executive branch is going to argue, their constitutional duty to repel an invasion, to remove, these domestic terrorists from the US. And so it says that this whole case was proceeding under the All Writs Act. And that's important. We're going to come back to that the government can't remove these detainees. And so, how did we get to the Supreme Court? Well, let's see. Remember, that case is pending in the Fifth Circuit. And Alito is saying, hey, we don't even, the Supreme Court doesn't have jurisdiction. One, the All Writs Act doesn't provide independent jurisdiction, which meaning that the court just doesn't have jurisdiction under that congressional law, that act. And so the Supreme Court would only have jurisdiction if the lower appellate court has jurisdiction. And that's actually currently at issue. The lower court doesn't even think that they have jurisdiction. And so what happened at the lower courts is that the district court didn't actually deny a request for a TRO. It was just inferred that it constructively denied it. So let's take a step back and think about this. So the petitioners, the plaintiffs in this case, this group of illegal immigrants who the government is saying that they're actually terrorists, they're part of this terrorist gang organization and that they need to be removed, they filed a motion for a temporary restraining order at the district court level. Now, the district court level didn't actually rule on it yet. The district court level judge didn't issue an opinion. It just said, hey, the court said that they were going to issue an opinion by some sort of deadline. Well, it looks like, based on what Alito is saying, is that deadline wasn't even a court-imposed deadline. It was a council-imposed deadline. So it looks like that the plaintiffs in this case, the attorneys for these illegal gang members, these terrorist members, which I think that they're represented by the ACLU, but I'm not for sure, that they actually said, hey, district court, you need to rule on this by X, Y, and Z time and date. And if not, we're going to deem that as a deemed denial, essentially a constructive denial. And so apparently the district court didn't rule at all, didn't decide yes or no on this TRO. Then counsel for the plaintiffs, again, these illegal immigrants or alien terrorists, whatever you want to call them, then they went up to the Fifth Circuit and they said, well, we're going to appeal to the Fifth Circuit. And then the Fifth Circuit said, well, we actually think that we lack jurisdiction. We can't hear this case right now because the district court hasn't even resolved it. You need to go back to the district court and either get that judge to either approve and grant your temporary restraining order or deny it. We don't have jurisdiction yet. You're here too early. The district court hasn't had the opportunity to actually rule on it. So the Fifth Circuit said, hey, we don't have jurisdiction. And Alito is saying, hey, if the Fifth Circuit doesn't have jurisdiction, then U.S. Supreme Court doesn't have jurisdiction either. You just can't, the U.S. Supreme Court can't just jump the line and say, hey, district court, we're just going to take this case and pull it up to our level and essentially grant the TRO. Because in effect, that's what happened. And so Justice Alito is saying, what are we doing here? We shouldn't be here. The district court didn't have the opportunity to even rule on this. And when he provides more information, you'll see. So it says that they requested a ruling on Good Friday within 45 minutes. So they said, "Hey, district court, we want an opinion within 45 minutes." And then after 133 minutes, when the district court didn't issue a ruling, which, when we do things like hastily, and I'm going to tell you as a legal professional, like, I always like to think on things, particularly really big decisions. I try to, if I can, give it a night's rest, because when we make like hasty decisions, they're usually not great decisions. And so they certified this appeal on the same day. So they asked the district court didn't issue an opinion within the 45 minutes on Good Friday that they wanted. And so then they went up to the Fifth Circuit, and the Fifth Circuit was like, "Hey, we're actually considering this and we're going to give it a decision. It's going to be forthcoming." And the Supreme Court actually issued their ruling before the Fifth Circuit issued their ruling. But Alito, because he's got some more time and issued his opinion after that, came back and said, "Hey, only like hours later, the Fifth Circuit came after the U.S. Supreme Court and said, we don't have jurisdiction because the district court like hasn't actually ruled on this. So parties, y'all are here too early." And so, but the U.S. Supreme Court, in, like I said, kind of bizarre fashion that I've never heard before, issued this midnight decision. And more glaringly important to understand is the government never had the opportunity to respond. So the only information that the U.S. Supreme Court had, that the Fifth Circuit had, that maybe even the district court had, was the pleadings of the plaintiff. They never had the other side. They never had the government's argument. And so that's this hasty, rushed opinion. And Alito points out later in this opinion that, well, in the plaintiff's information, they said that these plaintiffs are in immediate danger of removal. And that's why we're rushing. You got to stop the government from taking them out of the country. But Alito points out in a different case, which this is the district court in DC, another case, which I'm going to talk about, it said the government argued in that other case. So remember, we're talking about the Texas case, but this is the DC case, but similar facts, maybe different groups of plaintiffs, but similar information, saying that, hey, the government doesn't have any deportations planned. It's Easter weekend. It's Good Friday. We don't have any, the government didn't have any deportations planned for the weekend. And so Alito's saying like, hey, we're doing all this hasty stuff for a non-emergency. There's not actually an emergency. And the district court didn't even certify these plaintiffs as a class. And potentially the plaintiffs need to have habeas. They need to bring their lawsuits based on habeas grounds. And I'll explain what that is. But that they actually likely don't even have the ability to bring this kind of quote unquote class action lawsuit. And so they said that Alito's arguing that maybe based on previous precedent, these individual plaintiffs actually have to bring individual habeas corpus petitions, which that means the Latin, it's literal Latin says, where is the body, is essentially when someone who thinks that they're wrongfully being detained, wrongfully imprisoned, they can petition the court to say, hey, you need to look into this. I'm being wrongfully detained. And so I'm just going to sum it up. Alito's and his words, Alito and Thomas, their dissent. In some, literally in the middle of the night, the Supreme Court issued unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party within 8 hours of receiving the application, with dubious factual support for its order, and without providing any explanation for its order. Remember, it was 2 scant paragraphs. And so he says, Alito, in his dissent, continues, both the executive and the judiciary have an obligation to follow the law. The executive must proceed under the terms of our order in Trump versus JGG, and this court should follow established procedures. And so I'll go over those other opinions in part 2 of this video. And so this is the end of part 1. But if you're catching the live stream, I'm going to go ahead and launch into part 2. Okay, and welcome back to Military Law Talks. So this is part 2 of my video on this midnight unprecedented order from the U.S. Supreme Court on these planned deportations of, well, they're gang members, they're terrorist members. And so let's take a look at some other opinions that talk about these same sort of deportations and previous opinions. And so let's take a look at that. Okay, so this is a previous opinion from the U.S. Supreme Court, and this is the case that Justice Alito was talking about in his dissent. This is from the U.S. District Court of D.C. And so this was a previous case that went up to the U.S. Supreme Court, and essentially it stopped the TRO that was in place by the lower district court. And so again, it's concerning the detention and removal of Venezuelan nationals believed to be members of TDA. And it's been designated as a foreign terrorist organization. Okay, so in this opinion, it said essentially it got rid of the TRO, allowed the Trump administration to continue to deport these individuals, but said, hey, you're going to have to give them some sort of like notice and a hearing. And oh, yeah, it's likely that this district court in DC doesn't have jurisdiction because, and I'm not going to go through this entire opinion, but that these, the district court in DC doesn't have jurisdiction because historically how these cases are handled is that the individual who is being detained needs to bring a writ of habeas corpus. Essentially, where's the body? I have an illegal detention. So, hey, court, step in and get me out of confinement that I shouldn't be in. But that these individuals should be filing these habeas writs in the district where they're being confined, and they're mostly in Texas, so they are not in DC. So this lawsuit was filed on their behalf in DC, but these individuals aren't in DC. And so this opinion says like, hey, we need to follow precedent, we need to follow the law, and they need to file this case in the district where they should be. And then that gave rise to that second case in Texas that was pending at the Fifth Circuit that we just got this midnight order. So a lot of the same individuals, if not all the same individuals, I'm not exactly sure because they're not all named. They're now in this Texas case that we got this midnight order. But I do want to point out a dissent from this case, from this DC case. Okay, so I want to point out this is Justice Jackson, who, in many opinion, is probably one of, if not the most liberal member of the court, if you can kind of term it that way. I mean, I think liberal, right wing, left wing. I don't know. I think these terms are kind of meaningless. But anyways, so Justice Jackson is writing, and this is a dissent to that DC case, right? That said, hey, Trump administration, you can continue deportation. We're going to dissolve the TRO, but plaintiffs, you need to go file in the case in the district court where you are being detained. So like go back to court in Texas, not in DC. And so Justice Jackson writes this dissent, and I actually agree with a lot of what she writes in the dissent, and you'll see why. Okay, so this was April 7th, 2025. She says, I write separately to question the majority's choice to intervene on the eve of the district court's preliminary injunction hearing without scheduling argument or receiving merits briefing. Sound familiar? This fly-by-the-night approach to the work of the Supreme Court is not only misguided, it is also dangerous. Think about what she just said. So, yeah, absolutely. But then, 2 weeks later, week and a half later, the Supreme Court does it again. And so I'm continuing reading from her opinion. She says, when this court decides complex and monumental issues, it typically allows the lower courts to address those matters first. Then it receives full briefing, hears oral argument, deliberates internally, and finally issues a reasoned opinion. These standard processes may not always yield correct results. Sometimes we get it wrong, right? And she continues to say, but when we deviate from them, the risk of error is always substantially increases. Today's rush to conclusion that those challenging the government's action can only pursue their claims through habeas is Exhibit 1. Her and Sotomayor, the other dissenters to this opinion, says that they shouldn't have to just go through a writ of habeas corpus. They can actually also appeal the government decision through the APA. That's what they're arguing. And so she continues. She says it like, hey, this is like a misguided. We didn't thoroughly think this out. She continues, at least when the court went off base in the past, it left a record so posterity could see how it went wrong. See Korematsu, arguably, in my opinion, one of the like top 5 worst cases of the U.S. Supreme Court. This was what allowed Japanese internment camps in World War II. So I agree with her. That's a terrible decision. But when more and more of our most significant rulings take place in the shadows of our emergency docket, today's court leaves less and less of a trace. So yeah, I actually totally agree with her. So Justice Jackson says all that, and I do agree with her. But then she joins with the majority of the court in this most recent midnight order. And so she totally less than 10 days, right? What is it? Less than 10 days later, totally flip-flops and says, yeah, I'm going to join the majority in this really dubious opinion released in the middle of the night. Well, because it supports her objective. And so I thought that was an interesting, kind of really poignant. Again, like I said, I actually really agree with her reasoning, but then less than 10 days later, she totally goes back on it. So I thought that was an interesting, so that is to kind of explain part 2 of this video on this midnight ruling. And so if you like this video, please hit the like button. If you haven't subscribed to my channel, please do so and share this video out there. I have another video that I'm going to be releasing about how did we get here to this bad precedent regarding these TROs, and imagine in 2020 if the Supreme Court had acted with such haste and to stop the blatant constitutional violations that were occurring to U.S. citizens. So I'm going to compare and contrast how the courts are handling the supposed constitutional rights of illegal aliens comparatively and contrastly to how they dealt with the constitutional rights of U.S. citizens during COVID. So that's my next video. So thanks for joining me, and I'll catch you in the next video.